eyes on what the Supreme Court decides. Meanwhile, here's the latest update from inside the courtroom. Advocate Kishan Kaul, who was reading the Nebam Rabia judgment, is saying that this judgment states that the disqualification of the members cannot be entertained when the Deputy Speaker's own removal motion is pending. And in this case, Nilashish, it is pending. The Shinde camp has alleged and has said this in black and white that the Deputy Speaker's post is untenable.
Well, absolutely, Pranesh. The Nebam Rabia judgment, in fact, the relevant portion reads as such: when the position of a speaker is under challenge through a notice of resolution for his removal, it would seem just and appropriate that the speaker first demonstrates his right to continue as such by winning support of the majority in the state legislature. That is the relevant portion that has been referred to by Neeraj Kishan Kaul, and that is the point that he's continuously pressing. That, of course,
Advocate Kaul also saying, and this is important, I want to quickly highlight this. Nilash is coming back to you. Advocate Kaul reading from the Nebam Rabia judgment and says this is a violation of Article 179 of the Constitution. So what he means is what the Deputy Speaker, Mr. Zirwal, is doing in Maharashtra Assembly right now by disqualifying the rebel MLAs. This decision of the Deputy Speaker is in violation of Article 179 of the Constitution. Nilashish.
Well, absolutely. The constitutionality, the legality of this has been challenged, and it is being said by Neeraj Kishan Kaul that why would a speaker who is confident of his majority fear a floor test? Now, this comes back down to the crux of the argument from the Shinde side, that let's have a floor test, let's see how this goes out, let's see how it plays out on the floor of the House. Why would a speaker who is confident of his majority fear a floor test? Now, having cited the judgment, that is what Neeraj Kishan Kaul from the Shinde faction is in fact stating and asking in court itself. So the legality, of course, of the action of the disqualification notice has been challenged, but these questions...
What Advocate Kaul has said. Nilash, stay with me. When the position of a speaker is under challenge through a notice of the resolution for his removal, it would seem just and appropriate that the speaker first demonstrates his right to continue as such by winning support of the majority in the state legislature, thereby referring to what the Deputy Speaker has not done in this case. The Deputy Speaker has not just not responded to the letter written by the rebel MLAs, but he is also, as is the charge, acting unconstitutionally. Nilashish.
Well, absolutely. This is exactly what we have been breaking, that the Nebam Rabia judgment that is being cited is entirely on the contours of the Speaker's own ability to hold his position. Now, when the Speaker has been, his position has been challenged, it wouldn't seem appropriate or just for him to in fact hear anything else, especially something like a disqualification notice when his own position is under the scanner. Now, in this situation, Neeraj Kishan Kaul has stated that he had been informed of the situation. He has not responded, but he has chosen to issue notices as far as the disqualification plea is concerned and is going forward with that. So yes, the judges continue to discuss this amongst themselves as Neeraj Kishan Kaul is making these arguments from the judgment in question and stating that the position in law is very clear as far as the constitutional bench is concerned, and that a speaker, deputy speaker, cannot in fact take action when there is a motion for his own removal. So the status quo as far as the speaker is being questioned, the locus is being questioned, and there are further updates coming in that the Neeraj Kishan Kaul in fact is citing a couple of other judgments as of now to buttress his point, which includes a case against the Deputy Speaker of Arunachal Pradesh. So, of course, the Shinde camp, of course, is very confident and is vehemently opposing the action of the Deputy Speaker, and that is the first and foremost priority as far as they're concerned in not allowing a person whose position is already under question to take any action as far as disqualification notices.
Right, the highlight and takeaway of the argument so far is really this point made by Advocate Kishan Kaul. Why would a speaker who's confident of his majority fear a floor test? And Rahul Shivshankar, our editor-in-chief, is back with us on the latest that is happening. Rahul, the point made by Advocate Kaul is, why is the speaker reluctant to take a floor test?
Absolutely. So look, at the end of the day, there is enough precedent to suggest that these matters should be resolved on the floor of the House. But more importantly right now is the focus on staving off what is disqualification by the Deputy Speaker. So there's a laser-like focus right now by Mr. Kaul on the Deputy Speaker, saying that if the Deputy Speaker's role itself has been challenged, if he in fact should not be occupying the office that he is occupying, then who is he to act by disqualifying other MLAs from the House? So that is the thrust of it. If they can prove that the Speaker's actions, the Deputy Speaker's actions were ab initio void, then the Speaker himself, his actions themselves become ultra vires of the Articles 179C, etc. of the Constitution, and therefore disqualification is avoided. Any change in the strength and composition of the Assembly by disqualifying sitting MLAs for the period during which the notice of resolution for removal of Speaker is pending would conflict with the express mandate of Article 179C, Office of Speaker, with which the Constitution vests the authority to deal with disqualification petitions against MLAs, must surely be a Speaker who enjoys confidence of the Assembly. So the whole idea is, and this is what Kaul is quoting from the Nabam Rebia precedent-setting judgment. So any change in the strength and composition of the Assembly by disqualifying sitting MLAs for the period during which the notice of resolution for the removal of the Speaker is pending would conflict with the express mandate of Article 179C. So when there is already a challenge to the Deputy Speaker, when his own position is being questioned, then he cannot act. That is what the Rebia judgment has said very, very clearly. So it is obviously an attempt to suggest that the Deputy Speaker himself has acted ultra vires of the Constitution, because he himself is in no position to claim that he is a Deputy Speaker. That's the reason why there is this focus by quoting these precedent-setting judgments. This is the Babang Felix versus Deputy Speaker, Arunachal Pradesh Legislative Assembly. This is the particular case in which the Supreme Court had come out and made a clear precedent by issuing a unambiguous verdict. So that's really what is happening here. Kaul now reads Article 179 of the Constitution, which provides for removal of Speaker and Deputy Speaker. So he's now bolstering that, and I want to go across to Nilashish. Nilashish, this is very important, because if this argument falls flat, then the Supreme Court will uphold the decisions of the Deputy Speaker, disqualifying the MLAs, which will be a severe blow to the Shinde camp. So this is really a make or break moment, isn't it?
Well, absolutely, Rahul. This is the crux of the argument that has been persisted with by Neeraj Kishan Kaul, stating Article 179 at this point, which of course talks about the removal of a Speaker and a Deputy Speaker, and buttressing his point with the Rebia judgment, which is a constitutional bench judgment which holds great value in law, in terms of stating that if the Speaker's position in itself is under question, how can he go forward and take any other action when his own position is under the scanner? Now, this of course assumes significance, as you have been pointing out, that if the disqualification motion is allowed to go ahead by the Supreme Court, then that really in a way hampers the Shinde camp, which claims to have 39 MLAs, the cutoff mark being of course 37, the magic number being 37, which holds for 2/3, which prevents them from the anti-defection law, and that thereafter can be proved on the floor of the House. Now, as far as the Shinde camp is concerned, of course, now that they are going ahead with this line of argument,
okay, stay with us.